Okay, this is Professor Herskowitz again, and we're now going to do Chapter 9, which talks about the performance and enforcement of various contracts. So, a couple of things we're going to be looking at. We're going to go back over written and oral contracts in a little more detail, talk with more explanation on the statute of frauds as it relates to contracts. We're going to also talk about the different types of duties that arise and when those duties can be mitigated or abrogated based on the individual contract or things that are happening. And then we also understand how a contract is actually fulfilled or discharged. And then we're going to look at the consequences of a breach of contract with specific attention given to the types of damages. As you will hear me say many times, there are no punitive damages for contracts, but there are punitive damages for torts. To give a quick review, there are the 5 elements required for the formation of a contract. There's offer, acceptance, which comes to an agreement, a meeting of the minds. Number 3, there must be consideration, and 4 and 5 are capacity and legality. We've talked about those quite a bit. One thing that I want to talk about, and we did discuss a contract that is unenforceable, and one type of unenforceable contracts are a contract that is supposed to be in writing, but it is not. It's an oral contract. Everything else about that contract could be exactly what's needed to form a contract, so it would be a enforceable contract, but for the fact that it must be in writing, the court will not enforce it. And so that deals with real property, debts of others. It takes over a year to complete the contract, goods or services for over $500. Has nothing to do with with fraud. The statute of frauds merely states that the contract must be in writing. The writing, the formality does not have to be real formal. Any writing or a group of writing can be on several pieces of paper. They all come together to form the writing. It requires a signature by the party against whom enforcement is sought. So if both parts of the contract are not enforced, or it's only one party that's trying to enforce it, the party against whom the enforcement is sought must be signed. Thus, the contract may be enforced by one party but not the other. Any symbol that represents a signature, an X, a mark that will identify the person's signature. You can also integrate several writings. There can be several pages of things that are brought together to be incorporated by reference. Obviously, that makes it harder to interpret for the court, but it is possible. When you're talking about interpretation, businesses use a lot of pre-printed contracts. Parties type or handwrite additional items to be printed on the contracts. You also have annotations on the side. You'll have initials on it. Courts interpret handwritten terms to control over typed terms, and typed terms are controlled over printed terms. That's a hierarchy. If you're looking to see which of these terms that would otherwise contradict each other, the ones that are in handwriting are the ones that the parties will have to rely on most. The parole evidence rule. Parole evidence states that in a written contract, a party may not produce oral evidence, parole evidence, in court that changes the intended meaning of the written terms. So basically, it applies to the 4 corners of a contract, and somebody says, well, you also agreed to this outside of it. Parole evidence will not allow that oral evidence to come in to change the terms or add to the terms of the written agreement. The exceptions do allow evidence of oral agreement that explains the meaning of written terms without changing the terms themselves. So you can give oral evidence as to what was meant, but you cannot give oral evidence saying that the party agreed to do something else in the agreement. The contract is that which it is. Look within the 4 corners of the agreement. Parole evidence may be admitted if it shows that the contract is void or voidable, since there would be no contract then for fraud or illegality. It explains ambiguous language, concerns prior course of dealing, so that it's kind of explaining the language, but it's also saying that says this because this is how we were dealing in the past and it was understood by all the parties. and it can be oral evidence can be given to fill in the gaps so long as that does not change what is already written. And it can correct an obvious clerical or typographical error. So when you're looking at interpretation, rules that help words have their common meanings interpreted against the party that's drafted it. So whoever writes the contract has to live with it and the interpretation of the other party. Specialized meaning for specialized trade will be given weight in interpreting the contract, and anything that is handwritten supersedes anything that is printed. When you get into the contract itself, performance is required by all the parties. That performance is discharged from one or all parties with certain conditions. There can be a condition precedent in the contract if something takes place in the future before a party has a duty to perform. So a contract can say, when XYZ happens, then the party will be obligated. So that is a condition precedent. Until that condition is met, the other party is not obligated to perform. You can also have conditions subsequent. These are they excuse contractual performance if some future event takes place. Failure to meet a condition relieves the other party from performance. You have substantial performance where a contract is not completely done, but most of it's done. The work done is sufficient to avoid the claim of a breach. The party who substantially performs is entitled to a partial recovery under the contract. They may not get the full amount, but they don't lose everything because they have everything done except maybe putting in a door handle or something like that. Some contracts can be divided into segments or installments, which make it able to say, well, we've done 2/3 of the contract, we get 2/3 of the price, but it has to be naturally divisible, and it reduces the amount of dispute that arises due to non-performance. Many contracts are not divisible. A contract to build a home, somebody can't say I'm halfway there because I've got the roofs on and stuff like that. You're buying a completed home, not bricks and mortar to be laid on the front step. So not everything is divisible, and some things must be performed in their entirety. Excuses for non-performance, there are certain legitimate excuses such as impossibility and commercial impracticability. Impossibility excuses a party's performance. It must be objective and apply to any party in similar circumstances. There was a case called Parker v. Arthur Murray, which was not in this edition, an earlier edition, where a person was injured and could no longer walk, and Arthur Murray was suing him to fulfill his dancing contract. It shows the stupidity of attorneys sometimes suing a quadriplegic because he's unable to fulfill the dancing contract itself. Impossibility of performance is less likely to occur compared to impracticability. And increased difficulty or reduced profitability are not admissible evidence for the impossibility of performance. Look at this case of East Capital Development Corp. It gives some objective impossibility versus personal impossibility. It's a good case. Take a look at it and read it through. Commercial impracticability is what's called force majeure in contracts, acts of God, strikes, war. It makes it impractical for the party to perform. Look at the text for additional information on that. A waiver occurs when one party intentionally relinquishes the right to enforce the contract, and a party may release one party from performance if they want to. Breach of contract, when a party does not accomplish what they don't do what they promised to do under the contract. Remedies, there are damage awards, compensatory damage, consequential damage, liquidated damage. There are no punitive damages under contract law. Under equitable remedies, there's specific performance, injunction, and rescission. This is a chart that gives examples, discussions to talk about what is compensatory versus consequential. Liquidated damages are when a party cannot determine what the damages will be, so the two parties agree on a value in case there's a breach. be careful that liquidated damages cannot be so unreasonable that they become disguised punitive damages. It has to have some reasonable connection with the contract itself. So no punitive damages in contract. No punitive damages in contract. You got that? No punitive damages in contract. There are punitive damages in tort, which we'll be talking about later. Specific performance is very common in real estate transactions because every parcel of land is considered unique, and you cannot just pay somebody. They have the right to enforce the person to sell the property, to deliver the property that they had agreed to, because of the unique nature of real property. Understanding contracts is like the key to conducting business. Understanding the interpretation of contract law turns on a person's will make you a more effective negotiator if you understand what your rights are and what your limitations are, and it creates contracts that enhance business activities. Contracts is the heart and soul of business, so it's important you understand the various concepts to it. So I hope these chapters 8 and 9 and these videos have been very helpful to you in that. Thank you very much.